Good morning and welcome to Training Thursday's January 2017 webinar. Thank you for joining and Happy New Year. For those of you who are new to Training Thursday, my name is Hermie Abraham and I am the principal lawyer at Advocation Professional Corporation. We help employers minimize costly workplace issues so they can maximize the focus on their business. And we develop Training Thursdays to be able to help employers proactively know about the law and also proactively take these tips and tricks from the webinars so they will be able to implement them in their workplace. Live webinars are held on the third Thursday, typically held on the third Thursday of each month, and they last for about 30 minutes. And there's a new topic each month that is of relevance within the workplace. Now, before we get started with the webinar, a few housekeeping issues. Again, for those who are new to the webinar, you will know that we're using the Google Hangout platform. And between the time that I'm interacting and you're seeing the content, there is about a 20-second delay. So if you pause the webinar at any time, you will not be live. You will still be able to participate, but you will not be following live. And as well, if you put questions in the question box, which I'm hoping people will have questions, I will answer them at the end. I won't be able to answer them during the webinar simply because it will maybe not help with the flow. So I do look for your questions. If you don't want to answer questions within the webinar, please send them to me privately at info@advocation.ca. I'm always happy to help people answer their most pressing questions. And with that, we will get started. So the topic for this month is by far, I would say, the most important, and if I was to think of my employment law practice, the most busy area of my practice, because most workplace issues start and end because of a contract issue. And employment law is essentially business law, and business law is contract law. So if you think of the best way to be able to minimize your workplace issues, that would be in ensuring you have proper contracts. So the start of the year is always a great time for employers to turn their minds to their contracts so they can ensure that the contracts that employees sign when they hire this year are enforceable. And because I practice both in assisting employers and employees, I find that it makes me much sharper in this particular topic, because when I'm looking at a contract and I'm trying to find ways or see ways that employees can get more out of them, it helps me with the drafting of contracts for my employers, because I know the loopholes and some of the issues that the courts will pinpoint. So what I've done is I've picked the 5 areas that I've been able to poke holes in contracts and make them unenforceable. And we're going to talk a little bit about some of the strategies that you can take to be able to minimize these 5 common employment contract errors. So the 5 errors are: 1, the employer doesn't have a written contract with the employee. The second is that the employer has an ineffective process to be able to make sure the contract is legally enforceable. The third is that sometimes employers use fixed-term contracts in hopes to limit their liabilities, but in essence creating more. The fourth is that employers fail to include important clauses that are necessary for a particular position in the contract, and they have a one-size-fits-all. And then the last is that employers fail to review and revise their contracts. So it tends to be a one and done when in fact contracts are live and they should be reviewed from time to time. So let's delve into each of those topics specifically, those contract error areas specifically. So the first, failure to have a written contract. And I would say that most times most employers are good about having written contracts these days. About 5-10 years ago, maybe there was less emphasis on written contracts. Now we're seeing more contracts, although they might not be good contracts, but there are more contracts. But there is that error every now and then where it's a part-time position or the person's working casually and the employer doesn't think that a contract is necessary, or they're not senior enough, and so the employer doesn't believe that an actual written contract is necessary. But nothing can be farther from the truth. When you don't have a written contract, what happens is you still have a contract of employment, but it's an unwritten verbal contract of employment. And contract of employment, it is the terms of that particular contract is formed by the common law. And the common law is simply judge-made law, and there is a body of what an employment relationship will entail if it's not carefully specified in written form. So, for example, in common law, there isn't a automatic termination provision that applies to the Employment Standards Act. Let's say if an employer is looking to limit their liability to only Employment Standards Act and they don't put it in a written form, the common law gives an employee a better right or benefit. The common law also doesn't assume a lot of the post-termination obligations that employers might want to have an employee to be under when they leave the workplace. So the common law is really just kind of leaving, by not having a written contract and relying on the common law, you're leaving a lot to chance, and it doesn't really help with the running of your workplace and the management of a particular employee. The other thing is, if the matter does go to court, so if there's a workplace dispute with respects to what an employee thought about the contract and what they were supposed to do, and an employer thought what the employee was supposed to have or do, judges are most likely going to favor a credible employee. So if the employee believed that you made some kind of representation to them that they would get a 5 or 10% salary increase each year, you didn't have a written contract, after 5 years, their employment was terminated, maybe you've given them increases, sometimes maybe you didn't, but if you have made that representation, they would be able to sue on that particular point and perhaps get a 5% increase during, you know, if the termination notice period covered over the salary increase period. And you'd have nothing to sort of say that, it's nothing to prove as an employer, you'd have nothing to prove that that wasn't true. And I would say that judges are far more sympathetic to employees who lose their jobs because they feel that employers, if they want to minimize workplace issues, are in the position to do so by having clear contracts. So how can you fix this problem? Well, one, ensure that everyone in your organization, from the highest position to the lowest position, whether that be somebody who's just casual, part-time, even volunteer, ensure that they have a contract of employment. Ensure that they have a contract that explains exactly what's expected of them and what your obligations are to them. And make sure that the contract is fulsome. Oftentimes you just see a contract that's a one-pager. It doesn't really capture the expectations of the parties. If you have expectations for a particular role or a person and it was discussed, make sure that's in the contract. You want to ensure that your contract reflects the agreement and the reason why you're hiring the employee. They always say that contracts are the prenuptial agreements within the employment law sector, and I couldn't agree more. So this is your opportunity by ensuring you have written contracts before the employee starts work. So the second, I would say this is one of the bigger issues that I tend to see, is that the employers don't have effective process to be able to make those contracts legally enforceable and bind the employee to those particular contract provisions. So how does that create problems, or what are some examples? Well, one, sometimes employers provide an employee with an offer letter. Congratulations, we loved you during the interview process. We'd like to offer you full-time employment. Here's some general terms and conditions, and welcome on board. And the employee's excited. First day they come into work, then they have this long terms and conditions that they have to sign, and they sign it. The laws and case law has clearly said time and time again that that initial offer letter is the contract of employment. So employers who have a two-stage process where they provide an offer letter and then they provide a subsequent terms and conditions risk having those terms and conditions be worthless because the offer letter is the four corners of your contract. The second issue that you see is that employers give employees limited time to sign the contract. So employees are given this wonderful contract, lots to consider, but let's say their employment is to start on, Monday, January 30th, and they get the contract on Friday, the 27th. Doesn't help an employee to be able to have time to even review it with the lawyer. And when a judge sees that, or even when another employment lawyer sees it, if an employee has been terminated and is looking to see what their entitlements are, they will say, okay, well, you know what, you didn't have enough time to consider the contract, and so we can probably poke holes and make this contract legally unenforceable. Following up on that, oftentimes employers get employees to sign contracts after they start work. So they might give the contract to them ahead of time, but the employee doesn't sign it until after they start working with the company, or the contract is presented to the employee on the first day of work and they sign at the time that they start work. The issue is that with that particular problem is that once an employee starts work, you have an unwritten contract with them. If you want to have a written contract with them, you have to set out the terms well before the employee enters your workplace and starts performing those duties. So make sure that the employee never starts any amount of work before you're able to provide the contract and have them sign it. And the last is retaining the contract, the signed contract in the employee's file. Employers, sometimes the manager is the one that gets the employee to sign the contract. The manager puts it on a stack of other papers, and it gets lost in the shuffle. And so even though the employer has given the contract ahead of time, it's a fantastic contract, the employee had enough time to sign it, when push comes to shove and a contract needs to be produced, there is no contract to be found. And if there's no contract to show that the employee actually signed it, then there's no evidence or proof of the employee agreeing to those clauses, and the contract is effectively, void. So how can you fix that problem? I always say that you should centrally coordinate your employment contracts. And whether that's with one or two managers, whether that's with human resources, which is the best thing to do, ensure that you are managing all your contracts through one source so they know and have a bit of a checklist to be able to time when things need to be returned, and ensure that they have copies of the contracts on file. I always say that if you want to let an employee know that you're interested in them, you can express your interest to say, yes, we'd love to hire you. We're going to be providing you with our terms and conditions, which will be the contract that will form our legal relationship. So you can still give the employee assurances that you're going to hire them if the contract is not yet ready, but don't send out an offer letter or any type of letter that they have to sign unless that's going to be the fulsome contract that you want them to be bound to. And the last thing I say for human resources or managers or whomever is coordinating the contracts, create a bit of a checklist that you need for obtaining the contracts. So the checklist might have, if you're looking for somebody to start on January 30th, you know that 2 weeks before you want to send out the contract to an employee. You want to know that at least a week before the employee starts work, you've touched base with them to see if they've signed the contract. If they haven't, they should return it to you by a specific time. And ensure that once you get that contract, that the employee has signed it clearly, they've dated it, so it shows a date before the employee starts work, and ensure that your contract date that you have, that you type in when you're presenting the contract, has a date that you actually give the contract to the employee, not their start date or something else. So it's clear that there was a timeline for the employee to both receive the contract, review the contract, sign and approve the contract, and start work. Moving forward, the third improper use of fixed-term of contracts is the improper use of fixed-term contracts. And employers are well-intentioned when they use fixed-term contracts in some situations. What they want to do is hire somebody for a fixed term, which is great. But sometimes you have employers who just don't want to make a commitment to an employee. They're not sure if they have enough work, or they want this employee to be an indefinite employee. So they create a fixed term, maybe 1 year, maybe 6 months, whatever that time is. And they hope that it will limit their liability to the employee. Maybe they are also hoping that after the renewal of each contract, that the person is only a 1-year employee and that their severance obligations are never going to be more than a 1-year employee. But those assumptions are fraught with a lot of risks. some of the issues with fixed term contracts are that it creates a lot more administration for a workplace. So if you are hiring somebody and you do intend them to go beyond their fixed term, then you should probably hire them as an indefinite employee. To have them work after their fixed term, again, creates more issues. And if they are going to be hired after the fixed term, you're having to produce contracts again, which again creates much more administration and more chances that something will fall through the cracks. The biggest issue with fixed term contracts is the liability that it can create for employers, especially around termination. So one issue with fixed term contracts is if there isn't a very clear termination clause within the fixed term contract, the employee is entitled to the value of the full fixed term. And I actually, unfortunately, helped a client who had a fixed term contract, not drafted by me, but had a fixed term contract for an employee who started, the term was to be for something like a period of 18 months. And it was supposed to be an indefinite term working relationship. Just the employer wasn't sure about whether or not this employee would, really be able to cut the mustard. So they didn't want to keep them for a very long period of time. So they had an 18-month contract. The employee, after 3 months, was not cutting the mustard, and the employee terminated the employee. So the employee lost his job. I'm sure he was maybe sad about it, but he came back and said, okay, you know what? I'd like the remaining 15 months payment of my contract. And the employer was like, whoa, 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 I only have to pay you for 3 months. You've only worked for 3 months. I don't have to pay you for the full 18 months. And that's when they came to me, and I had to break the news to them that if you don't have a termination clause in the fixed term contract, unfortunately, case law has overwhelmingly, and there's been some recent cases as well too, have overwhelmingly said that employers are required to pay out that full fixed term, that you've made a commitment to a person for that full term, and that's what you're legally liable for. So not having that fixed term termination clause is going to be harmful to you, whereas if it was, an indefinite term contract, yes, maybe it wouldn't be the best contract, but you're only looking at common law notice for 3 months rather than having to provide somebody with the full, additional 15 months worth of pay for not doing anything within your workplace because you've already terminated them. And the other thing with fixed term contracts, which kind of goes back to issue number one with having an unwritten contract, is once that fixed term expires, unless there's wording in it that says that the terms and conditions are going to continue for subsequent terms, it's over. So your contract does not apply to them anymore. So if the contract's fixed term is to end on Friday, January 27th, and the employee starts work again on the 30th, and they continue on for another 6 months, that 6-month period of time is not covered by a contract. It's not covered by the contract that's expired. And so if you're providing termination, you're going to be providing termination to the employee based on the common law and not based on what you have written in your contract. So how do you fix this? Well, I always say that you should always draft your contract with your employment goals in mind. So what does this mean? If you are truly hiring somebody for a very remote project, let's say you're hiring them to fix a website or to do work on a specific campaign, there's a start and finish, a fixed term contract makes sense. So draft it with those employment goals in mind. If the person is having an indefinite role, then make them an indefinite employee, and you can always terminate. There's nothing wrong with terminating or ending the contract early. I always say that indefinite term should always be your default. So think about the job. If it can be an indefinite term and it's not really just a project that they're being hired to, make it an indefinite term contract. And make sure that you include contingencies for early termination. If you are going to use a fixed term contract, make sure that you have a very solid termination clause that states what is going to happen and what the employee is entitled to, so that termination clause is not rendered unenforceable and you end up being on the hook for the full value of the contract. The fourth issue in contracts that I find is the failure to include important clauses. And I've just captured a few of those clauses, but there are a host, and again, I could go on about how important these particular clauses are. The first is the probation clause. There's lots of thoughts about the probation clause, whether or not it makes sense. But I always say that, again, contracts are your chance to set the expectation. So if there is a probation period and the employee is being assessed, you should have that in contract. Now, people say, oh, well, the Employment Standards Act gives us 3 months of probation, so I don't have to put that in my contract. Well, actually, you will have to put that in your contract, because nothing from the Employment Standards Act is assumed, especially probation. So if you don't have a probation period that says, a probation period clause that says that you can terminate within probation in accordance with the Employment Standards Act, or by providing minimal notice in accordance to the Employment Standards Act, then within that first 3-month period of time, if that person's not working out, you will still have to provide them with termination notice. Whereas if you have the probationary clause and it's very clear that it's going to be a probation in accordance with the Employment Standards Act, you only have to pay them up to their last day of work, which is significant. Overtime is becoming one of those litigious areas. So I always say that the contract should be very clear about the hours of work, what's expected, what is your salary based on. It should be based on 44 hours of work and not 40 hours of work. It should also clearly state that overtime needs to be approved, so people aren't just generally working overtime. And it should also give them a process for which the employee should request or be, confirm that they're working overtime. So that needs to be very clear in the contract ahead of time, before the employee starts working, so there's no question, and you can rely on that if there is ever a court case later on about the employee working excess hours. Employers often have policy manuals as part of their organization too, and the policy manuals contain a lot more information about what the employee is required to do. That policy manual should always be incorporated into reference in the employment contract, so you'll want to make sure that you have a clause there to reference the policy manual and incorporate it into reference. You'll also want to ensure that you're giving a copy of that policy manual to the employee at the time that they're getting the contract. Bonuses are highly litigious. Employers always feel that bonuses should only be paid to active employees. Case law is very clear that active employees also include employees who are on a period of notice. So if you've terminated an employee and provided them with 8 months of notice, they'd be entitled to 8 months of bonus, unless your contract clearly states that they're not. So you'll want to make sure that your contract has very clear bonus languages. Termination and layoff, that's a biggie. We've talked about it before, but if you don't have a termination clause, you'll be on the hook for common law, and the common law is far more generous than what most employers would look to pay. And it's also very ambiguous in the sense that you don't know what employee might ultimately get. So it's better off to sort of specify ahead of time what your expectation is in terms of employee when they're terminated. Layoff provisions, you'll also want to make sure that you have those. So if you have to shut down for an act of God, there's a flood, the people can't come in, that you have to shut down work for some time because of a slowdown, that you can also call in to reference the layoff provisions within the Employment Standards Act. If you don't have that, then if you lay off a person, it can be a constructive dismissal and they'd be entitled to notice. And the last is the post-termination obligations. Employers often assume that once employee leaves, they're still bound by a lot of the duties, like, don't solicit my clients, don't compete with me, don't use confidential information inappropriately. But once an employee leaves your workplace, they have no more obligations to you. So if you want them to have obligations, you have to put that in the contract, and they have to sign it before they start work. And so all of the reasons that I explained is how you fix your contract. Make sure that you're, again, drafting it with your employment goals in mind. If you have a key employee who's going to be working with sensitive information, make sure that you have some post-termination obligations, because you want to make sure that that employee is not going to use that against you in their next job if they resign, or if you're fired, or if they're fired. Use clear language, and there's a legal term called contra proferentum, and what that means is essentially that the person who drafts the contract is the one who's going to be liable for any errors or issues that come up with respect to that contract. So if you have said that or have a termination clause, or let's say hours of work clause that doesn't say that the employee is working up to 44 hours, then, you know, as the drafter of the contract, you have the opportunity to dictate whatever you want. And if you don't put that in, the courts will see it, use it against you, and they will take the employee's explanation, if it's a reasonable explanation, over yours. And the last thing I always say is ensure that you have an entire agreement clause. Sometimes employers make promises to employees, or maybe employees hear promises during the recruitment process, and they expect those promises to carry forward. They're always going to get a salary increase. It's going to be no less than 5%, and whatever it is that they hear during the interview process that might be discussed and maybe misinterpreted. If you have an entire agreement clause, what you're saying to the employee is everything that's in this paper is what we agree to. And so if it's not in this particular contract, we don't agree to it. And you know, this is your opportunity to let me know if there's anything missing. Once an employee signs a contract with the entire agreement clause, they're basically saying, yes, this reflects our understanding. So it's harder for them to come back later on and say, no, well, you promised me during the recruitment process that I will always have a 5% increase. You can look at the contract and say, well, it's not in the contract. This is the entire agreement between us, and nothing else applies. And you, as an employer, would be successful in that particular argument. And the last area that employers sort of have issues with their contracts is that they draft them and they never review them or seek to revise their contracts after they've been drafted. And the fact is that laws change all the time. Employees change within a role, and contracts can become outdated very quickly. 2012, there were some cases that came out that changed the way termination clause language should be written. A lot of pre-2012 employment contracts that were drafted no longer were, you know, good. And so I still see employees who come in now, they were hired in 2014, and they have contract language, termination contract language, that is not consistent with that case that came out in 2012. There's lots of cases that came out last year with respects to bonuses and what's expected, and as well with fixed term contracts and overtime. So you always want to make sure that your contracts are up to date. It might not help for the employees who've already signed contracts, but for the new ones who are coming on, you're limiting your liability. And even for the existing employees, you can always enter new contracts with them by providing them with either a signing bonus for the particular contract, or by, you know, giving it to them when they have a promotion or they're changing jobs, again, provided that you're still meeting the criteria to give it to them before the actual promotion or job takes place. So yeah, remember that the contracts are constantly changing and that you should keep pace with them. So how do you do this? Well, review and update your contracts at least annually. I say that that's a good way to start the year, and part of the reason why I have this webinar at the beginning of the year, so you know that your contracts are going to be legally enforceable and that you've at least captured the status of the law up until that particular part of that particular time. You also want to create a policy for a process for obtaining new contracts from employees. So for example, if an employee has been with you since 2010 and now they're going to be moving into a new role, this is your opportunity to ensure that you now have them signing the latest and greatest that might be able to further, you know, refine not only what you're looking for from that particular position, but also limit your liability if the employment relationship comes to an end, either through the employee resigning or through you having to terminate them. And that process should be in place, again, managed through HR and the managers, so there's no chance that employee who you might want to switch on to a new contract ends up starting the position before the contract is actually signed. So with that, I will take any questions that have been posted, and this is your opportunity to ask questions now. While I do that, I should say that I am running a promotion for contract reviews, and I'm doing it for a limited time because it's a bit of a steal. I really focus on preventative workplace issues, and contracts, as I say, are the biggest areas. So for a limited time, I will be offering a promo where you can review your contracts for only $500 plus HST, and it will allow me to look through your contract, see that it includes the latest and greatest with respects to the laws and changing legislation, and that way you'll be well set up for 2017 and beyond as you look to hire your employees. So I will send out details of that promotion with the webinar replay link. And as we've come to our end of time and there are no questions right now, I will just turn your attention to the fact that our next webinar will be held on Thursday, February 16th from 9 a.m. to 9:30 a.m. The topic is on the law of constructive dismissal, a very pertinent topic these days with changing workplaces, changing requirements, and even I would say managers that aren't particularly good at managing people. You don't want to create liabilities for your organization with these issues. You don't want to necessarily have to pay out severance. So tune in next month so we can learn about the law of constructive dismissal so we can avoid constructive dismissals in your organization. Thank you so much for joining us. Again, as I always say, our time is our most precious resource. I appreciate the time that you spend with me this morning, and I look forward to spending time with you again next month at the next webinar. Thank you very much.